Never a dull moment in the Murdaugh trial, guys. Okay, so you've probably heard that the defense team has filed a motion in the appellate court because, of course, right now the defense was in the middle of preparing their appellate brief regarding his conviction last March. So they have filed a motion to suspend that appeal and a motion for leave to file a motion for a new trial in the trial court. I know that's a mouthful, but that's procedurally why they have to do it, because right now it's technically in the appellate court. Now, the allegations themselves are very troubling, and they center around alleged conduct by the clerk of the court that the defense has basically termed to be jury tampering. And the timing of all this seems to have stemmed from the clerk of the court, Ms. Rebecca or Becky Hill, the timing of her book that she published in early August. So that apparently is the timing issue of why this is all coming out now. So today's video, I'm going to go through and give my takeaways on what we know so far of what I see for the strengths and the weaknesses. All right, so let's get to it. Okay, takeaway one. If the allegations are true, I think there's a very good chance that Murdaugh might get a new trial. We have 2 jurors that have provided sworn affidavits. Now, again, they're just allegations, but when you have sworn affidavits from jurors, that's pretty serious stuff. So we have to wait and see, but I think if the allegations, even half of them are found to be true, I think that Alex Murdaugh is going to get a new trial. And I don't know that makes anyone happy, except for the defense team. Okay, so takeaway 1. Takeaway 2. The clerk of the court is an elected position, and that's important because that means that she's a state actor. Now, I looked at South Carolina, and the clerk of court is an elected position. They serve 4-year terms, and basically they're kind of the COO, this chief operating officer of the court. They make sure that the court proceedings run smoothly. They coordinate with jurors on administrative things like lunch plans or travel reimbursement, etc. They run the business of the court. But what they're not supposed to do is speak to the jury about substantive matters of the case itself. And that's what the concern is here. So my takeaway is the state action part. You'll recall from the press conference that Jim Harpootlian stated that they also had sent a letter to the U.S. Attorney's Office in South Carolina suggesting that they conduct an independent investigation into the allegations made in this case. That's serious because that involves a state action, and you have a whole host of potential federal and state, but federal for sure, potential violations by someone that's in the public trust. And that could mean potentially criminal. So again, way too early, but we'll need to take note of that and see what happens. We don't know, but that is something that stuck out to me, is that she is a state actor. So something to keep in mind. The other thing I think of my takeaway is I think we're going to see some challenging from the prosecution and the defense on what's the standard. Now, generally speaking, in an appellate situation, the standard is that, okay, even if all this happened, would that have changed the outcome of the trial? And that's a very high standard to meet, as you can imagine. And that's why, most appeals are not successful. But there is case law which the defense has cited that when you go to things like jury, interference with jury, you're talking about the Sixth Amendment, those type of situations is something that deserves a different burden of proof. And what the defense has claimed and cited Supreme Court cases and South Carolina cases is that when you have an independent third party with allegations that they have been contacting with the jury, then that's a different bar. That if that's found to have happened, then the burden shifts to the prosecutor to be able to show that the subject matter of the communication was harmless. and could not have affected the verdict. And that's really important because if you recall, what we saw in some of the affidavits that we'll go over in a couple minutes here, was that was really core to the allegations that are being made about the jury tampering, is that the allegation that the clerk, the day before, the day of the defense was going to start presenting their case after that President's Day holiday, that she, made these comments about, you might hear things, just be careful, listen closely, watch closely. That's the type of stuff that we're talking about. So I'm really interested to see what the state says on that point as far as the burden, but I think that's going to be a really interesting legal issue to look forward to. Okay, so there's takeaway number 3. Okay, takeaway 4 is one of the things that I think is one of the stronger pieces of evidence that, if proven to be true and credible, is that's juror number 630. So I'm going to insert the affidavit here, but I'll point out what I think is most concerning. And again, this is a sworn affidavit from an actual juror. We'll talk about the other affidavits in a little bit, but this one is, again, in the bucket of, I think, strong. But here you'll look. Towards the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. I mean, guys, that goes to the central core of the case, as Jim Griffin pointed out during the press conference. She also instructed the jury to watch him closely immediately before he testified, including look at his actions, look at his movements, which I understood to mean that he was guilty. But those are the things that I think are the most damaging from this affidavit. The other thing I think that is damaging about this affidavit is the information about this idea that the clerk was trying to move things along and get that quick verdict, which, remember, I was surprised that they came back in like 3 hours. So they, I'm showing here, when we began deliberations, Ms. Hill told us this shouldn't take us long, and that if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but were told they could not smoke until deliberations were complete. The other piece of evidence that I think is very strong for the defense is the affidavit of Juror 785. This is the juror that is affectionately called the Egg Lady, and this is the juror that was dismissed, if you recall, actually the day that they were going to deliberate. She was basically made it to the whole end, and then she was dismissed. So her affidavit is super interesting. So I'm going to go ahead and insert that here now. And she says here, during the presentation of the defense case after President's Day, but before Mr. Murdaugh testified in his own defense, Colleton County Clerk of Court Rebecca Hill told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdaugh's attorneys. So again, you're seeing this cooperation from one juror and then another juror with similar language, which, I think would tend to argue towards potential credibility, because that same language is being corroborated by a different witness. Here's where we get to the Facebook stuff. Now, I think what's concerning about the Facebook stuff and is the new allegation that the defense is making, that essentially she made up the Facebook story, which is really troubling if this is true. So to take a step back, at the time of the defense's testimony, when they were ending their testimony, I believe it was that Friday, and they had the defense had rested. Ms. Hill had said that she had gone on Facebook that evening and had saw a post about someone saying that they were the ex-husband of a juror and that this person was kind of running their mouth. That was kind of the gist of the situation. And she said she kind of saw it, and then that was that. But apparently that weekend there was also an email sent about a separate issue that did involve this juror and some allegations about whether she had spoken to some tenants at one of she apparently is a landlord, and one of her tenants that weekend, she had delivered a refrigerator, and there were some allegations that she might have actually shared her views of the trial with her tenant. Okay, so that's kind of the background. Now, when the court asked Ms. Hill about this Facebook post, she said that they weren't able to find it. And what the defense has said is that there's some question as to whether the Facebook post existed, which is troubling if that's true. But she did say that one of her colleagues was able to find a post that the supposed ex-husband posted the next day that apologized, and they included those Facebook posts here in the affidavit. In fact, I'll show those here. Now, if you really look at the Facebook post, it doesn't look like it has anything to do with anything about a trial. It looks like it was like some person made some mean comment, apologized for it, and then the commenters are saying, okay, go to the Lord and, don't give up on, being a good person and stuff. So, I mean, I didn't see anything about the trial in there. So it's odd. But in any event, what's troubling is a couple of things. First of all, we have an affidavit, which I'm showing here, from this juror 785's ex-husband, where he confirms in a sworn affidavit that it was never him that did this whole Facebook post, and he even allowed the defense to download his Facebook history. So, got a problem there, because we now know this definitely wasn't her ex-husband. But I thought was more troubling was the conversation that apparently took place with Ms. Hill and this juror, I'm showing here in the affidavit, alone in the clerk's office. I mean, this should not be happening. See, she questioned me. She summoned me to speak with her alone in an office in the courthouse. And remember, the clerk of the court is like a elected position. If you're a juror, I mean, I could see that someone might be potentially intimidated, like, oh my gosh, am I in trouble? But anyway, this is where Ms. Hill apparently tells the juror about this post, and she said, look, I don't know anything about this. I haven't been drinking with my ex-husband. In fact, she apparently even showed her a picture of her ex-husband, and in fact told her, I haven't talked to him in 10 years. In fact, I've got 3 restraining orders against him. And she says later on in her affidavit, she's scared of her ex-husband. So, but the thing that's concerning here is that apparently, so she has this first conversation with the juror in her office. But then she comes back and talks to the juror later on that same day and tells the juror that the SLED and the Colleton County Sheriff's Office went to her ex-husband's house and confronted him about this. Like, what? That's just crazy. But then she tells, so Ms. Hill, according to the affidavit and the allegations, says that she told this juror that the husband confirmed he did it. Which, if she did say that, that's a lie, because the husband said he didn't. Anyway, that's concerning. Like, why are you sending SLED to the ex-husband of a juror? Like, what are you, the police? Like, and remember, the court even comments, and that was put in this motion. The court says, gosh, I wish she hadn't been talking to jurors and had just come to me. So I think that's a problem, and that's also why we think that the judge may be a witness to this evidentiary hearing, assuming that the Court of Appeals allows them leave to file. So that was a problem. So I think it's not so much that even that she ultimately was dismissed. I think that what's more concerning is that when this issue of this Facebook post came up, the fact that she had this private conversation, that the clerk allegedly had this private conversation with a juror alone in her office, and then later on said SLED went to the house and he admitted he did it. I mean, that doesn't sound good. That was really concerning to me, and I think is a strength for the defense's argument, was that the day that she was actually dismissed, that morning when she was going to she was getting on the bus to go to the courtroom with the other jurors, she looked at her phone. She was getting a call from her ex-husband. And so it freaked her out. She didn't answer the phone. And so she actually wound up using the bailiff's phone, Mr. Bill. I love how they call Miss Becky Mr. Bill. It's so Southern. It's cute. Anyway, Mr. Bill, she borrowed Mr. Bill's phone to call the clerk and tell her, like, I'm freaked out. And the clerk allegedly said, Murdaugh's probably got to him. Now, again, if that was said, that's not good. But then apparently she then goes on to ask this juror, well, what do you think about his guilt? And they have this whole blown conversation about what the juror thinks the strengths are of the case and what the juror thinks the weaknesses are. I mean, this see what the other side comes out. We have to see what Ms. Hill says, right? But if that's true, that's very concerning. Okay, so now that we've talked about the strengths, let's talk about some weaknesses, because there are a few weaknesses. The first one that I would say is a potential weakness is these affidavits of the paralegal that were based on her conversation with 2 other jurors. So it looks like from the affidavits that there were definitely 4 jurors that were spoken, that the defense was able to talk with. 2 of the jurors do not have sworn affidavits. So that basically means all this is hearsay, and whether or not the court allows this into evidence ultimately will be a question of whether they can get it in under an exception. I also think it just sounds weird, like, okay, this looks like these conversations took place in the August timeframe. Like, one of the reasons that that the defense gave for not having one of the affidavits was they weren't able to meet and coordinate a time for them to meet back with this juror after they initially met with them and get them to actually sign the affidavit. Because how this works is the lawyers draft up the affidavits based on the conversation. And then the way it's supposed to work is then the witness reviews the affidavit, provides any corrections, and then ultimately the final form is provided and the person signs off on it and it's notarized. That's how it's supposed to work. So that is some, administrative and coordination that goes on with that. But it still is weird because this is so important. You think that, I don't know what's going on there. I don't know why there's 2 jurors that don't have affidavits. So that's something to me that I think that the prosecution can, use to their advantage. And the other thing too is because we don't have their sworn affidavit, we just have the sworn affidavit of the paralegal reiterating what was communicated in that initial meeting. These jurors haven't signed a sworn statement, so they could say something different when if they are actually, brought to testify in an actual hearing. So they may say something that's very consistent. I'm not trying to say that there's anything nefarious going on by the paralegal at all. I'm just pointing out that this isn't technically their sworn statement. So, we don't know if they'll say the same thing once they're actually questioned. The other kind of thing that I think is a potential negative or weakness is that I'm not convinced all of these allegations about the conversations that the foreperson had with the clerk. I mean, it looks bad, right? Like they're always meeting, and supposedly the clerk said, you can't ask us about these questions, my conversations with the foreperson. There were some allegations in one of the affidavits that when the jury visited the Moselle property, the foreperson and the clerk were kind of walking together. I don't know. I think you could go both ways with that. We don't know what was had in those conversations. And again, remember, the clerk does have a role to play, and it would make sense that the person you speak to when you're trying to coordinate issues with the jury, such as breaks or dinner or lunch, all that, you would speak to the foreperson. That's the person that's meant to be the representative of the group. So I don't know. And I think that might be some puffery there. I'm not quite sure. I haven't been convinced yet that that's necessarily so damaging for the prosecution and so helpful for the defense. The other potential weakness is when I was reading Juror 785, Egg Lady, she was questioned by the judge of course, about this Facebook post. And if you recall, that was an in-camera hearing. So that was out of the presence of the jury and the courtroom. So none of us know what was said, except for the people, the juror, and the people that were in that room, right? The court and the two sets of attorneys. So, but apparently what happened, and I'm inserting the testimony here, is that the judge, when he was questioning her about this Facebook situation and these other things, he specifically asked her if the clerk had discussed the case with any of the jurors. And he specifically said it twice. He says, has the clerk discussed anything about the case with anyone on that jury? And she said, not that I'm aware of. So, that's an inconsistency that's going to probably be pointed out, and it could be a credibility issue. Now, it could be that she was like, look, I wasn't even thinking about it. This was intimidating, and I didn't really think about it at the time, or what have you. I don't know, but that is a potential weakness, right? There's some inconsistency potentially there. So what do you guys think? I think overall, we're going to, of course, have to wait and see what Ms. Hill's response to all this. We understand from her co-author that did an interview on Court TV that she has retained a lawyer. I think that's smart. And that they would be providing a statement at some point. I haven't seen one yet. But, I just don't know what she's going to say. She could have some innocent explanations for some of this. I think I mentioned the one where I'm not so sold on with this 4-person, like the private conversations. She may have innocent explanations for some of this stuff. She also might plead the 5th. So, we'll have to see. Now, the state has 10 days to file their response, so I'm really looking forward to that response. They're in a tough spot, right? Because it's like, on one hand, you don't want to do a whole other trial that no one wants anything to do about that, right? I'm even thinking myself, I'm like, am I ready for another Murdaugh trial? But then you're going to defend some of these allegations. If some of these allegations are true, this is serious. This goes to the core of the sanctity of our system of justice, right? The sanctity of a jury. This should not happen ever. I think that's why everybody is so incredulous about it. So how do you respond by the state? I don't know that you want to be defending some of this stuff. So it'd be really interesting to see what the state says, and also to see if they do take issue with the standard of review that I mentioned earlier, that the defense has made, that basically if you show any of these allegations are true, the burden goes to the prosecution, and it's not about whether he would have won at the end of the day. It's whether the communication or the conduct went to a central issue in the case, which of course here is the credibility of Alex Murdaugh. So, never a dull moment, right? I think though, I'd say with what we know now, and that's a big caveat because we don't have the response from the state and we don't know what Ms. Hill's going to say. But as I said, if any of these allegations are true, I think it's likely that Murdaugh is going to get a new trial. And at the very least, I think he's going to get his hearing. I do think he's going to get, I think this case was so important and so public and so international interest, right? I think it has been called the trial of the century in South Carolina. I don't see how you don't allow an evidentiary hearing and really get down to the bottom of what was happening here, right? There's a lot of reputations of the clerk. My God, she could be, there might be some criminal issues going on. So I think it's in everyone's best interest to get to the bottom of this. And I think that's what the defense wants. That's what Jim said he wants. He mentioned, we're not investigators. We don't have subpoena power. We can't force people to talk to us. They give us the Heisman, right? So, a court hearing would give them that ability to use those discovery procedures to be able to have those conversations and really get down to it, and again, do subpoenas, even do subpoenas for, he mentioned records, phone records. So, oh my God, though, if we have another trial within a trial within a trial, I don't know if I can handle it, because you could also see this going off the rails, because remember, Murdaugh was never supposed to go 6 weeks. So I don't know. Oh gosh, I don't know. But in any event, that's my takeaway as of right now. Assuming half of these allegations are true, I think they I think they get an evidentiary hearing, and if half these allegations are true, I think there's a strong chance for a new trial. But we'll have to see what the prosecution and Ms. Hill say. Well, thank you so much for joining. Never dull moment. Be on the lookout. I'm just finalizing part 3 of my Charlie Adelson trial countdown. And we have the Sarah Boone hearing tomorrow. It's just all sorts of fun in La Belle land. But thanks so much for joining, and I hope to see you in my next one. Bye.